Hello, I'm carrying on with liability of public bodies, and now I'm going to look about protecting the public against crime. So the senior courts have this policy-based justification against a broad duty of the police to protect everyone from crime, because the police cannot protect us all from all offences all the time. They're trying to do that, but it's something which is completely unachievable. So the public policy reasons mean that there is no negligence liability, and that was first found in Hill against Chief Constable of West Yorkshire in 1989. It went to the appellate court and then to the House of Lords, which found that the police don't have a duty of care to an individual to find and arrest a killer before he kills again. Their noble lordships, they said that a general duty to protect all members of the public from crime would be just completely unworkable, and it would wreck police operations. I mean, how do they prevent every single crime happening? If they only concentrate on murders, then thefts would go through the roof. And if they only concentrate on thefts, then we'd have more murders. So the principle was found in Brooks and Commissioner of the Police of the Metropolis, 2005. So the claimant saw the racist murderer's friend. He sustained post-traumatic stress disorder. And he said that's partly because of how he was treated by the police. After the murder, they thought he was the perpetrator. This is Duane Brooks, to do with the murder of Stephen Lawrence in 1994. But the claim against negligence was rejected, and Lord Stein said the following: the core principle of Hill remained unchallenged in our domestic jurisprudence and in European jurisprudence for many years. If a case such as the Yorkshire Ripper case, which was before this House and Hill, arose from a decision today, I have no doubt it will be decided in the same way. It is, of course, desirable that police officers should treat victims and witnesses properly and with respect, but to convert that ethical value into general legal duties of care in the police towards victims and witnesses would be going too far. Close quotation. So after Hill, the same principle was found in Osmond and Ferguson. The identity of a suspect was known for a time, and the identity of likely targets was also known to the police. But this led to deaths because the police did not take action when they found out that the police was absolutely obsessed with one of his pupils and was likely to commit a serious crime. The teacher began to campaign to harass the Osmond family, and he eventually killed the pupil's father and wounded the student. So the Court of Appeal was willing to accept this is different from Hill because there was already a relation of proximity between the claimant's family and the police. The Hill immunity was applied, and the case failed due to public policy. The Court of Appeal found that the claim should have been struck out because there was no cause of action, and that even if all the facts alleged by the claimant were true, the claim was going to fail in law because the police were said to have a kind of immunity. So after the rejection of this claim, the case went to the Human Rights. There was European Court of Human Rights, Osmond against UK, 1999. The court found there was no breach of Article 2, the right to life. They said there's a narrow rule when the state can violate the right to life by not protecting the public. And we've seen this in some cases since then. And this is what the European Court said. It must be established that the authorities knew or ought to have known at the time of the real and immediate risk to the life of an identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers which, judged reasonably, might have expected to avoid that risk. Close quotation. The court said relying on police immunity was a violation of Article 6, the right to a fair trial. After that, there's been influence on subsequent cases within the United Kingdom. It's now accepted that this was a miscomprehension, and we don't need to think about that anymore. But all these cases need to be considered in the light of the Supreme Court decision Robinson against Chief Constable of West Yorkshire Police 2018, which went to the Supreme Court, and it found the rules for tort are similarly applicable to public bodies and private persons. So Robinson, an old woman, she was badly injured and knocked to the ground when the police were trying to arrest a fleeing drug dealer. The decision to arrest him at that time and in that place ran a foreseeable risk that a member of the public would be accidentally injured. So the police were negligent, and the trial judge had held the Hill principle, though, they're protected against claims of negligence. So this was a key decision. The Supreme Court looked at the line of cases and said that they applied the Hill principle, and the Appeal Court had relied on it and found that a duty of care did not exist. But the Supreme Court said that the police were liable to the injuries to the claimant because they're trying to arrest the suspect, and the conduct of the police was an act, it wasn't a failure to act, and therefore they're subject to liability according to the usual principles of liability. because there was a foreseeability of the injury that was done to a bypasser. This woman was just passing by, and she was knocked over and injured accidentally by the police whilst they're apprehending a suspect. So this was a foreseeable consequence of their negligent acts. The duty of care about positive actions has to be differentiated from imposing a liability for omissions to act. The common law doesn't usually impose liability for an omission to act if that causes a harm to third parties. Only in the most extraordinary circumstances would they be found liable for that. So let's look at Hill and how the public policy and justifications can be superseded. The principles that we've looked at and the important cases are about failures to protect the public and witnesses by the police or other public authorities. And in these cases, there were claims of negligence pursuant to the ECHR. Anyway, the claims failed. There are important public justification reasons for the public policy reasons. Brooks and Commission of the Metropolitan Police of the Metropolis, Michael against Chief Constable of South Wales Police, and Van Carla against Chief Constable of Hertfordshire. And also another one, Smith against Chief Constable of Sussex Police 2008, which went to the House of Lords. So this was about serious domestic violence. Michael and Chief Constable of South Wales Police led to a contentious Supreme Court ruling in which 5 of the seven judges upheld the policies behind Hill. The claimant was attacked by her ex-boyfriend. He left saying he'd come back to kill her. She then made 2 calls to the police. They were only 6 minutes away. The calls were mishandled, and the police finally came to her home 20 minutes later, and she'd already been murdered. So an action was brought in her name against the police in negligence under Article 2 of the ECHR. The ruling in favour of the police defendants was based on two reasons. First, there was no duty of care because the situation didn't fall under the exceptions to the general rule against tort liability and omissions. Particularly, the call handler had not said anything to the dead woman that showed a particular assumption for responsibility for her safety. Second of all, the duties owed under the HRA are owed to the public in general and don't give rise to individual actions in private law. So this opinion predicted the future of Robinson 2018. Lord Toulson said the utility of the Caparo three-part test in these situations was still valid. There was no proximity. That's what you need in a circular case. They framed the question in the answer. He didn't believe the concept of immunity was useful in these cases. There's nothing more than application of the usual principle that a person cannot be liable for failing to control the actions of another. In Van Carla, the Chief Constable appealed after a ruling against the police who'd been under a duty to take preventive measures to keep a witness safe when he was being threatened, and he was shot days dead before he could give evidence in a court case. The claim was under Article 2 of the ECHR. The claimant and Smith brought the action under common law. He'd told the police on numerous occasions that his former girlfriend had threatened to kill him. The police had plenty of evidence that these threats were realistic and claimed the police had no excuse for not preventing the harm, and because a hammer attack was carried out which caused major injuries, and the Court of Appeal had been right to find the police were not immune from negligence liability in these 2 cases. So in both cases, the appeals against liability were permitted. In Van Carla and the Osmond test, the police knew or should have known at the time the shooting was a real immediate risk to life, identified from individual criminal acts of a third party. In relation to Smith's claim, the balance of the advantage was in keeping the principle that was laid out in Hill. So in the absence of special circumstances, police do not owe a common law duty of care to keep people safe from harm caused by felons. In Smith, the Court of Appeal said that in cases involving the police, the proximity between parties cannot only create a duty of care, but can override the public policy reasons that would otherwise bar the action, as Swinney said. So whether that's under Article 2 or common law, it's not a valid reason of distinction that an informer is entitled to protection, whereas a witness is not. And doesn't this show the justification of the Hill immunity against police action in negligence is becoming unsustainable? There was Mitchell against Glasgow City Council 2009. The issue for the House of Lords was whether the local authority had a super responsibility to protect one of its social housing tenants who, after a long campaign of harassment, was murdered by another tenant. But the local authority, when aware of the victim's neighbour might do something after being told that he would risk being evicted, the required element of relationship of responsibility was not there. It was not fair, just and reasonable to impose this duty on a public body, coping with the very difficult duty of handling antisocial behaviour amongst tenants. Because kick him out, well then you've unhoused him and that you're in breach of that duty. So in Robinson, the Supreme Court cited Mitchell as an example of what public authorities, like private individuals and bodies, don't owe a duty to individuals to prevent them from being harmed by the behaviour of a third party.